Hello, everybody. This is Haley Lynn Gray, and I have got a phenomenal guest with me here tonight. This is my fabulous attorney friend, Cate Cole from Australia. And tonight I wanted to talk to you, and we wanted to bring to you a great topic. And we're talking about patents, trademarks, copyrights, and IP law, so intellectual property law. And it is not my subject matter of expertise, but it is certainly Cate's. And it is, important that you understand at least the basics about IP law, especially if you were doing a large amount of business online and you have websites and you have copy and you are using graphics in places, and that you have like a good solid understanding of what protections you have and what protections you don't have. And welcome, Cate. So good to have you here.
Thank you for having me, Haley. Hi, everybody. From down under, the day after your day.
Yeah, it's Thursday there now. Almost midday Thursday.
Yep.
It kind of always boggles my mind when, you think about, the whole dateline and, what time is it there and what date is it there? And it kind of can get a little bit weird at times, really.
Well, yeah, we can talk to each other in different years.
Absolutely.
I've had conversations with people in, you're in the year, so it's fun. It's actually fun. And it's great to be able to talk to you and to talk to everybody. So what do you want me to start?
Yeah, let's do it.
Yeah, I think one of the things that's really important to think about when you're thinking about intellectual property and your business, I like to break it down for some people because it seems like a really big topic, and it is. But some of it isn't relevant to everybody. So the way that I like people to look at it is this. If you think about your brand, your income, and your content. So if you think about the way that your business is branded, whether you have a logo, whether you have a name or something like that, that's the first thing. Your income, so, obviously your copy is your income, and sometimes the stuff that's on your site, but it's about how you're protecting your income. So do you have client contracts so that they deal with the issues of confidentiality? Do you have a structure of your business to deal with that? Do you have the protection in relation to those things? Well, we talked a bit about that last week, but the things that are really kind of relevant here are your brand and your content. And so your content obviously covers the stuff on your website. It also covers any of the stuff that you share with your clients or any of your audience, any images that you have. And also, other things that might come up in a program or, anything like that. So brand, when you're looking at how protecting your brand, there's a couple of things that you would look at. You'd look at trademarking your brand or putting a design protection on it. So it really depends on whether you would want to, whether you would actually want to do that. But I would suggest if you have a name that you like or a phrase that you like, you would trademark that phrase. And you would use that in conjunction with your logo if you had one. So it may not be that, but it might be a combination of letters or whatever it is. So trademarking, that's really important, because if you don't do that, then anyone can use that name. And we know that, when you have a name that's a good brand, that people will actually, people will know your brand. So there's a huge amount of financial benefit to having a well-known brand, as we know, because, brands like Coke or Nike or Pepsi, let's not mention Pepsi, but, anyone that has those big brands and the logos that are associated with them, we know that they're of a certain quality and they've got a certain reputation. It's the same even in a small business. So you need to register those. So trademarking is a specific process that you can go through. You can get an attorney or a lawyer to do it. You can also do it yourself if it's not too complicated. So depending on what kind of business you are, it's actually not that hard to do it yourself. You just need to know how to go about it. And I'm happy to talk people through that process at some point. The other thing that you can do is in terms of your I'll go into what a trademark is. So essentially a trademark is saying to the world, so you do it in your own country and then you can register it worldwide. And it's signified by, well, we know the little TM that you see on beside certain, logos or whatever. That TM is only relevant until it's actually finalized, and then you see that little R in a circle. That means that it's a registered trademark, and that anybody who uses that trademark, once it's been registered, can be prosecuted for breaching the trademark. So it becomes a legally enforceable part of your business, and that means that it actually has a money value, if that makes sense. Because it gives you as a business owner exclusive rights to use that and also to sell it commercially. So you could build up a business that's hasn't made a huge amount of money necessarily, but the trademark is, the brand knowledge about that and the brand awareness is very high. And so you could sell that and probably sometimes people get more money for their brand than they actually do for the business itself. Does that make sense?
Yep.
Yeah, so it's really valuable. And, if you're working in this area, I think people tend to leave it because they think, it's just an added expense. But I would really encourage you to do it because it can be worth a lot of money.
Right. And Elizabeth Pampelon makes a comment that some logos made by logo mills cannot be trademarked or registered.
That's true. So you just need to be careful about the originality. So what happens when they look at trademarks is they look at the originality and they look whether or not it's, you might be able to do that if they give you permission to do that and you're using it in conjunction with your name. But you need to be really mindful of that because sometimes trademarks will get rejected on the image and not the name, but because they're put together, they then become a rejected trademark. So you just need to be really mindful of that. In most countries, trademarks attract a fee for registration. It's usually for about 10 years, but you need to check your country. And then what happens in your country is that you can then register it with the World Intellectual Property Organization under a treaty called WIPO, WIPO. And that then gives you worldwide protection. So what you find, it's probably the easiest to go to your country only and then do it through the WIPO treaty, which I can talk people through at some point, or you can come to me and I can help you with it. When you do that then, so say I registered a trademark in Australia under Australian law, and then I went and did the international one, then nobody in the US could do it. I could do it another way and just say, okay, I'm going to do it in Australia and I'm going to do it in America, but I'm not going to do it anywhere else. But that would be a little bit crazy. Because all our countries have signed up to this treaty, once we've done it in our country, it then gets recognised worldwide. I think it attracts a fee, but honestly, it's worth it, and it's a deductible expense. Well, it is here. I'm not sure about there, but I'm sure
Anna Yoga says worldwide. What is called?
Oh, World Intellectual Property Organization. So it's called. It's actually It's called, if you just Google WIPO, WIPO, you'll see that it'll come up as the World Intellectual Property Organization, and we all signed the copyright treaty, but it all falls under that. I can give you the link if you like, or have you found it?
I just typed it out. I think she can go find it.
Yeah. It's pretty easy to find it, but if you have any issues, just contact me. So the trademark thing is so trademarks are very separate. So they're separate in the sense that they're your brand, but they're also related to protecting income in your business. Because as I said, if you want to go on and sell that business, your trademark might be the most valuable part of your business. It may not, but it can become a very, very lucrative part of your business. And when you look at the assets of the business, when you're making a sale, your trademark will be valued on there. So I think it's a really important thing to look at. In terms of copyright, every country has a different copyright regime, although it's pretty much standard. Like, we all apply each other's law in one way or another. But let's just be clear about it. What is copyright? So if I have an idea and I share it with Hayley and I just say, hey, I've got this great idea for a drink bottle that you can wear on your head while you're talking on Facebook. And I'm going to tell you about the reason, like the way that I'm going to sell that. Okay. That idea is just an idea that I've shared. It's not captured anywhere, right? So unless we've recorded it or we've written it down and I send it in an email, there's no ownership in that idea. The thing about ideas is you need to commit them to some sort of form. And I mean form in inverted commas. The law needs something to hold on to, okay? So I don't know if anybody's read the Elizabeth Gilbert book, Big Magic, but if you read that book, you will understand. She's got this beautiful metaphor about how ideas are floating around in the world, and sometimes an idea comes to Hayley, and then sometimes she says, oh, not right now, and it comes to Kate, and then it moves on to someone else, and finally it finds an owner. And you know, sometimes when you think, I had that idea, that person's stolen that idea, but you haven't committed it to anything. The person hasn't stolen the idea, according to Elizabeth Gilbert. She's saying, well, actually the idea is just floating around looking for an owner. Now, I know you couldn't use that argument in a court, but what you do need to do for courts is to commit it to something. So if I have an idea and I write it down and I share it with somebody, I own that idea. I own the copyright in that idea because it's on a page like that, okay? Or if I've drawn a picture, or if I've, recorded it in a song, or if I've, done a mime in a dance or something. I don't know, but now we're getting silly. But, or I made it into a movie, that's actually that's committing something in terms of committing it to a form. Mm-hmm. So the way that the court sees copyright is as a bundle of economic rights that protects the items that have been authored by someone. So the idea has been authored, if that makes sense. And we know that we see things in like paintings. You can't reproduce a painting without getting permission from the artist. Photos, pictures. So we know that we're learning more and more about that as the internet kind of, with marketing more. People are saying, hey, stop lifting my Instagram, pictures and, without attribution and that sort of stuff. So it covers a whole lot of things. It covers paintings, photos, obviously writing, pictures, graphic designs, drawings, any sort of form of image or song, music, sound recordings, Kindles, blah, 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 blah. So it covers a lot of things.
And people have been, caught really hard when they've downloaded pictures and say use them on their website, and they don't realize that it belongs to Shutterstock or Getty, and they don't have the rights to use the image, and they've gotten caught by hundreds or thousands of dollars in fines.
Yeah, you've got to be really careful, particularly with those big organizations, because you owe so every time that you use an image, there's a sort of a fee is attributed to that. So so you need to get permission. That's why you have to buy those images off those image bank places, or you have to at least, and you can't just buy the cheapest one and say, oh, I'm buying it for I don't know, $50, but I'm going to use it on my website, because that's for commercial use. So you need to buy it for the purpose that you've done it, and that's what we call licensing the image. So you don't own that image. You can't then sell it on or do anything. You've got a permission to use it in a specific space for whatever it is. If somebody assigns their copyright to you, so that would be like in a contract says, okay, I'm assigning, this book over to Hayley, mm-hmm. Then she owns the copyright, then she has the economic right. So it transfers from me to her, just like it would if I sold you my car, right, or I sold you my, pencil case. I don't know, random things that I'm thinking of as I'm sitting here. So in Australia, copyright's automatic. So as soon as it's committed to a form, it's owned by the person who created it. It's in America, you can register copyright, but it's also arguable that if you are the author, then you own the copyright. The problem is sometimes, particularly I think in online world, who did it first and how do you prove that? So I think it's important that if you've got something that's really valuable to you, that you actually register it as copyright.
Now, one of the things I've seen happen lately to Bushra Azar and a couple of people is massive copying of, say, coursework or something else. How do you address something like that?
So if you see that somebody has, if you believe that somebody has copied your work or you've been told that and you see that they have done it, the first thing you need to do is send them a letter to inform them that you're aware that this course is, for whatever reason, like this course is similar to yours and that you believe that you're the author of the work. If the work has been registered, then you can also send, proof that you own the copyright. In Australia, for example, where you don't need to register copyright, you just prove that, you just say to them, I own this, and so you're basically telling them to cease and desist. So and I'm going to have a pool of letters that you can access on my website so that you can get those easily, because they're kind of hard letters to write if you're not trained in that. And you also want to just say the right thing, but you also want to keep a legal trail of what you're saying to the person.
Right.
So the first thing I would do is contact them and say, it's come to my attention that you've done this. You need to, take it down, please. If they don't do that, you say, okay, I'm going to give you 7 days to take it down, or I'm going to start legal action. And you can also, at that point, probably you can contact their their web hosting. I don't know the language, but the host people who host your website. And if you tell them that they're in breach of copyright, they'll probably take the site down until it's resolved. They can actually shut down an entire site until that stuff is done. And you probably then need to decide whether you want to litigate and take action.
Right. And it would be in the United States, it's the DMCA, and you can also have a DMCA takedown notice.
Yeah. Okay. Great. Thanks for that. So yeah, you can do that. The most important thing I think to do when you have a situation like that is make sure that, start it off with it. Some people don't realize that they're doing it. I know that sounds crazy, but honestly, people are, a bit thick. So sometimes I think people are just so oblivious to what they're doing. They just inadvertently copy something. I don't know how you could do it, but I don't know. Some people, I've done a lot of mediations in my time, so I know people can be a bit clueless. And so it's not necessarily malicious. It's just, they're naive.
Right.
Some people are deliberate about it.
And
I think you just need to approach everybody with I don't know, the same kind of attitude, because it'll just serve you better. So just say, hey, I can see this. These are the complications. Take it down in a nice way. The second time, if they don't do it, then I'd go in hard.
Right. And what about sharing photos on Facebook?
In terms of your photos?
In terms of copyright and trademark and getting into trouble for sharing a photo on Facebook. Yeah,
you shouldn't do it unless it's your photo. So basically, or you need to attribute the photo to whoever it is. So if you're using, the rule of thumb should be, it should be your photo. You should own it, which means that you've either purchased the right to use it or you took the photo. Okay. So if you haven't taken the photo, then you need to be really careful about ownership. So I'm really mindful about that stuff, and I would only I mean, in some places you can get free photos, you know, they're happy for you to share. So those photos, you just need to keep a log, or you need to keep a kind of like a spreadsheet of the photos that you've taken and from what site or whatever. So I know that sounds like you have to do a lot. It's a bit complicated, but honestly, if somebody comes along and says that photo is mine, you need to know where you need to be able to track back quickly where it is, so that that you can say to the person, hey, I got it from this site. Because you might be inadvertently sharing something that's been stolen. So you just want to be able to, cover your bases.
Mm-hmm.
The other thing is, you don't need to put that copyright symbol on things, but people like to do it because it looks, I don't know, smart or legal or something. But the little C means, copyright is owned. It's not necessary because, but I mean, knock yourself out with it. It looks kind of cool. So, I think the main thing around the copyright stuff is check in your country whether you need to register copyright. I know in Canada and the US and the UK, actually, you can register it. In Australia, we can't register it. But in any event, all countries, if you are the author, the original author, and you can prove that, then you should be okay. It just, I suppose if you're going to want to rely on that in the countries that you can register it, then it might be safer for you to register it. The difference between that and patents is patents are for design, for inventions. So, and it's a really, really complicated area of law, and it's a really, really complicated process. So you have to be able to break down your invention into steps, and you have to be able to prove that each step of that is original. It's like, it would take me way too long to talk about it. I don't think there would be anybody, I mean, there might be, but if you are interested in that, let me know and I can point you in the right direction. But even when you are in the invention space, my husband is inventing something right now. And it is so complicated. And also people who invent generally don't care about whether they're being protected unless they're a big multinational corporation, because they're too busy inventing the thing. They can't be bothered with lawyers poking their nose in, like their pesky wife saying, hey, you should be patenting that. So patents are a kind of a whole other area, but they're for inventions. But they're also for things like, a special hot chocolate, or a special way of having a diet, like a diet drink, or a special, soda drink or whatever. So, or a special sauce, like in some of the, I don't know, some of the special sauces that you have in things. So they're all patented, and the secret ingredients are they have to break down each step to talk about, how it's kind of a, it's a novel idea. I think that's the language they use, novel. Okay, I just wanted to talk in terms of IP. I also wanted to tell people how to stop people from stealing your ideas, because that's a question I get all the time. I don't know if you get it, but I get it all the time. So one of the things I would say is make sure that if you have an idea that you and you want to share it with someone, that you've already committed it in writing somewhere or in a form, like in a material form. And if it's not possible to do that, or it's like if it's if it's on the run or it's been swirling in your head, make sure that you have a policy or you've got the person to commit to confidentiality. Because if you have a confidentiality clause in any, discussions that you're having with colleagues or with other people who, in a business sense, then you need to be really clear about the confidentiality. And then, you can say, well, this was a confidential discussion, so you're not to take it outside of this space. So be really clear about confidentiality. I'd also, and make sure the person's agreed to the confidentiality. If you're sharing it within colleagues, like in a group, make sure that you've got them all to sign a confidentiality deed before you give them any information, particularly when you're doing joint ventures and stuff, because people just, that's what people actually go there for, fishing for stuff. If the person refuses to do it and says, hey, don't you trust me, blah, 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 then I would say, actually, no. To to be honest. And so, you know, I like
I
you,
love
but
that.
I like you, but I don't trust anyone in this situation. And so, you know, and actually just take a step back and say to yourself, if this person isn't willing to do this for me in terms of this idea, then, you know, why should I give them my idea?
Right.
The other thing, yeah, and with also with employees, just be mindful that they've also signed a confidentiality deed, because sometimes I've seen litigation where the employee has stolen the idea because everybody else is bound by confidentiality, but the person's like, oh, I trust them, they've been working in my business for years, and they steal the idea inadvertently or, you know, deliberately, but either way it's gone, and then they've committed it to a material form, and so they own it. So just be careful of that.
Yeah.
What other things could we talk about?
So what is your first step that you take, like if you suspect somebody has taken your intellectual property?
Well, the first step, you need to compare it and see whether or not it looks substantially the same. So, but I think you need to do, take a deep breath. Okay, don't react in any kind of, you know, a reactionary space. Like, just take a deep breath. It's not like a medical emergency, so you don't need to go in all guns blazing straight up. Like, just take a deep breath and look at them side by side. Okay, now with a photo, it's pretty easy. With a painting, it's pretty easy. With text, sometimes when it's jumbled up a little bit, it's not so easy. So just have a look at it and then get someone else to have a look at it. And if it looks like substantially the same, then you need to, the first step would be like take a deep breath and then like just compare the two or three or whatever it is, compare them. And then get somebody that you trust to have a look as well. You know, say, hey, what do you think?
Right.
Because sometimes people have like jumbled up some of the words, but substantially the entire thing is exactly the same. So you need to be really mindful about that and make sure that you're clear about what they've copied. And then write a list of what you think they've copied. Like, have they copied the structure? Have they copied the topics in each, say it's a program. So they've copied the topics, they've copied the structure of the program, they've copied, you know, the exercises that you do in that. They might have taken chunks out of some and swapped them around, but it's substantially the same text. The second thing then I would do is write to them immediately and tell them that this has come to your attention, and that you are asking for them to explain themselves and also to cease doing it.
Right, and I think screen captures and everything else.
Oh yeah, sorry. Yes,
completely appropriate here.
Yeah, please capture everything. Please get evidence of everything that you've seen along the way, including messages that people send you about the situation. Because you need to have the evidence, because people delete stuff all the time, as you know. So people kind of fly in and fly out. So collect evidence. That's a really good point, Hayley, actually. And, you know, I'm not a fan of people like screenshotting and, you know, sharing stuff for the sake of it. But I think in this case, if it's your business, then you need to do that. And then really collect it, you know, kind of mindfully. Make sure you can collect the date on which you saw it. So try and get a screenshot of the whole screen, and also where it's being posted and all that sort of stuff. So that's a really good point. And then make contact with the person. I always, in a situation like that, I always say to people, look, I think the best thing is to, while you're kind of taking your breath, just collect the evidence before you approach the person, because sometimes they'll block you or they'll create all these barriers for you then to take action. So make sure you've captured that evidence before you approach the person. And then you can also provide them with evidence. So, that's a really important step.
Yeah. I mean, a lot of like overwhelming stuff here, but I think that the overall message is use only your own content. Don't take other people's content.
Yeah. Yeah, 100%.
And know where your stuff is coming from.
Yeah, I think if you're not taking the time to find out where you're getting stuff from, then you might need to slow down a little bit. I think that there's a real push to get as much content out there, but you know, it's really hard on people, particularly artists and authors, when their work is, you know, it's a very emotional connection with their work, and to have it being used in ways that might be derogatory to the nature of the work, or, I mean, apart from the fact that it's like, if you steal someone's car or you steal someone's belongings, you know that that's an offense, right? It's the same thing if you're stealing someone's content or you're stealing someone's images. It's just that, you know, it's easier to do it without getting caught quickly, but you will get caught. So I think you can't cut corners with this stuff. And if you set up a good practice at the beginning of your business, then you'll just be in the practice of taking the time to do it. And I think that's something that I always try to encourage people to do, and I'm sure you do too, Hayley. It's like, just if you have a good practice up front, then you know, you won't even be bothered doing the other stuff because you're just used to doing it the right way. I think when you're trying to cut corners, something's going to give, and you might inadvertently start taking stuff that isn't yours.
Absolutely.
Yeah.
And, you know, and while it's okay to look at other people's websites and get ideas, it's not okay to copy their websites.
No, it's not. It's not okay. And it's, you know, you want to create relationships online that have a longevity. Like, you want to have these relationships with people for the long haul, and you never know when you're going to need people. And just because they're on the other side of the world doesn't mean that you're not going to bump into them somehow at a conference or at some sort of event. You know, it is a small world. It is a small world. It's a really small world. And the online world has a really uncanny knack when there are people like me around, I guess, that are willing to sort of, you know, say, hey, this isn't cool. So there's definitely yeah, I just have a good practice around this stuff. It's not hard to do it. You know, I mean, I'm sure everybody takes, you know, beautiful photos that they can recycle or whatever, or at least,
Absolutely.
You know, borrow or an attribute. That's what you need to do. You need to be attributing it. You need to be saying, this is by somebody else, and I'm, you know, using it or whatever. And if you get approached by somebody who says, hey, you know, you've used my image and you really didn't mean to, just say to them, I'm so sorry. You know, I apologize, I'll take it down. Now, I know a few well-known entrepreneurs who were teaching for a while a practice of just using the image, and when people approach you, just say sorry and then take it down. I mean, I just don't agree with that. And, you know, I think that, yeah, if you've got the idea that you're doing, if you know that you're not doing the right thing, just don't do it.
Right. It makes perfect sense to me.
Yeah.
And, you know, it's not always easy to create all of your own stuff, but there are so many free resources out there and amazing tools that you can use to create stuff. And, you know, proper attribution goes a long way. And I've had clients who have asked me, well, can you take that image and cut off the other person's watermark or, you know, logo off the image? And I'm like, no.
You can, but you shouldn't.
No.
Exactly. The thing is, you know, there might be ways to do it, but you don't want to do it, because when you're doing that also, if that got prosecuted in a court, the court would say, you took the time, you couldn't even run the defense. I didn't know, because you've taken the time to take that thing off. So if the person can show that image first appeared online with the thing on, and then suddenly it appears on your page with it off, the court will say, well, it was originally, you must have taken the time to cut it off. So, you know,
off with your head. Yep.
Yeah. So, and you may not have even done it. You might have borrowed it from a friend who did it. But the point is, if it appeared online originally like this with a logo down the bottom or whatever, and then it appears on yours with something else, you could be, you know, equally as culpable. So I just don't do it.
Anna asks, how do you know if someone owns a photo if there's no copyright sign on it? Well, that's the problem with using content that's not your own, because you don't know where it came from.
Yeah, and you know what? Well, you don't know who owns the photo, but there are some ways to run through images, like an image thing, to find out images being used and stuff. But I don't know, you might have to talk to someone else about it. I have no idea. But
there's software that you can run it through, but you know, generally photographs are not safe to use.
They're not safe to use because if it's not your photo, then obviously it was taken by someone else. And if it was taken by someone else, you don't own it. Does that make sense? So,
and there's probably somebody with a license on that photo.
Totally.
Don't use other people's photos on your blog without their permission.
No.
And there are photos of uncertain pedigree. Don't just go to Google Images and find an image.
No, definitely don't go to Google Images. That is a recipe for a lawsuit. So you need to go, if you want to get free images, if you can't afford that, then go search that out. But you still need to attribute in some of those. So just be aware of that. But there's plenty of sites that you can go get free images, or just go out with your phone for a day and take some photos of, I don't know, mountains or grass or whatever you want to use the photos for, and then just use them. And you know what? There's so many great filters that you can use on your crappy photos that you may as well just, you know, filter the heck out of your photos and you know, make your own image. But I just think just don't do it. And it's also the same as taking photos of like drawings or something. Like you can't do that. You know, just because you take a photo of a famous painting doesn't mean you've got the copyright to, you know, reproduce it.
Right. Yeah. Anna says, well, on Facebook, everybody uses it and shares. And to some extent, you know, you're maybe talking about memes, you know, which generally people put their information on. So you've got the attribution on the image right there. But, you know, if you're talking a true photograph, like a picture of a flower or something, or something that is an actual photograph of something, that's where you really run into a lot of hot water. Memes kind of are understood to be something I think people share.
Yeah, I agree with that. Yeah, I agree.
You know, but you wouldn't want to alter a meme and cut off somebody's watermark or logo off of it either.
Yeah, that's right. No, you shouldn't do that. And I mean, I think that the meme thing is kind of interesting because generally it's photos. Well, I've got a bit of a thing for Barack and Joe Biden memes. And, you know, but those photos are generally taken by, you know, they've been circulating for ages. And I totally agree that is in, you know, I guess
technically,
technically a breach of copyright. But generally those photographers that take those are the official photographers, and they're kind of out there already. But and so in a sense you're just sharing the meme itself. But I agree that is technically a breach of copyright. But you're not using it for commercial use. If you're using something for commercial use, it puts it into another category of breaching copyright, because it's actually then
you're making money on it.
You're making money on it. That's right. Yeah. Okay.
Share it but not sell it, then it's okay, you're saying? For a meme-ish.
Yeah, I think you still need to be mindful of memes, but I think it's like, because the interwebs is, I can't even believe I just said that word, but because it's so, gets circulated really quickly, particularly through the young folk. You know, you're probably safe with that, but I'm not saying that it's not illegal, if that makes sense. So I'm not saying that I mean, I just think you need to be mindful of that, because if someone took exception to that, they could actually bring action.
Mm-hmm.
You know, and really, if it's being shared on Facebook and Facebook are allowing that, and they get notified that that's a breach of copyright, they should technically take that image down from everybody, from wherever it is.
Mm-hmm.
And I'm sure they've got some way of doing that.
They have all sorts of interesting ways.
Yeah. So I think I think if you're making money on it, then that's problematic.
Yeah.
Yeah.
I can see that.
So other questions?
If somebody wanted to get in touch with you, how would they find you?
Oh, well, I've got a new website, so I'm really super, super, super excited about it. So there's two ways to get in touch with me. You can contact me so my website is sisterinlaw.com.au,
Mm-hmm.
but don't be scared off by the AU because I can talk to anybody anywhere. The other place people can email me is at, oh God, what's my email address? drcatecole@gmail.com or kate@drcatecole.com. It's Kate with a C. Or you can find me on Facebook. You can just message me through the Sister-in-Law Facebook page, or you can find me. It's Kate with a C, Kate at Dr. Cate Cole.
Mm-hmm.
I'll put it in here.
I've got it.
Oh, okay, cool.
And Anna was commenting that some music Facebook will take down if it's copyrighted.
Yeah, that's right.
Absolutely.
That's right, Anna. And they'll also do it on YouTube as well. Yeah, she does type fast. Yeah, I think it's Kate at, not Kate with a K. I don't know why it came up.
I figured I came up with a Kate on that.
It's okay. So they do it on YouTube as well. So I think, and that's the other thing on YouTube. I mean, YouTube are really good at policing that stuff. So they'll also do it with, even when there's music played with images. So sometimes because copyright only lasts for a certain period of time, and it's different in different countries. So I think it's 75 years or something. So for example, Mozart's, sheet music is free for all of us to, unless it gets, but it becomes part of the public domain. So, but say somebody publishes that and then puts, so somebody plays the piano, a beautiful Mozart piece, but they have flower pictures from, I don't know, like a famous artist, Annie Leibovitz. Which, I don't even know if she takes photos of flowers, but whatever. Oh, I thought that was the doorbell.
That's my clock.
Oh, I was like, it's my doorbell.
I have a couple of old clocks that chime.
Okay, then YouTube will actually take down the whole video because they're using someone else's images. So even though the music is fine, the images may not. So you just got to be really mindful of that stuff when you're putting stuff up on YouTube or on Facebook or on Instagram or whatever. So just be aware of that.
And Facebook will take down lives that have music in the background.
Yeah. So, I think it's easier with music too because people identify with it really quickly. So they'll either complain or it'll somehow get picked up. But it's a little bit harder with text. But I think you need to be mindful about text. And I think I saw something that Anna had written about quotes in that thing, which I know I shouldn't be looking at Facebook, so I'll get off.
You're all good.
And that was, yes, you need to attribute quotes because that's another thing that I find really, I get really annoyed, but it's actually horrible for the person who created the quote or the person who owns the copyright of that material, which is, a quote from a great person and then the person's business thing underneath it. It's like, dude, you didn't say that. That was Nelson Mandela or that was, Gandhi or that was, Mother Teresa or something. It's just like, you can't hold, because the other thing you need to be careful in relation to that stuff with quotes or sayings is if you put something like that on in some countries like Australia, that could be considered false and misleading advertising. And so the government will come in like a ton of bricks. So you need, if you start, have something up there and it's just, it's a saying by someone else and it looks like it's attributed to your business, somebody could argue that that's false and misleading advertising. So be really careful about that sort of stuff. And, you know, at the end of the day, if you just put your own stuff up there, that you're super cool. It's easy.
Mm-hmm.
It's easy to do the right thing.
Yeah, it is easy to do the right thing. And it's very easy to mistakenly do the wrong thing if you're not paying attention to what you're doing.
It is, and I think you should just learn from that. Like, don't, you know, beat yourself up or anything. If you've accidentally done something, just, you know, apologize and then just don't do it again, and learn from your lessons. I think that's the main thing. You know, we're not perfect, so I think just do what you can.
Mm-hmm.
Yeah.
Inez says she created her logo from scratch using clip art format of images. Most images can't be copyrighted because they're basic designs, such as a bowl, a cup, and so on.
Who said that? Who said that?
Inez Moore?
But who said she couldn't copyright it?
I don't know.
Oh.
I don't know that I agree with that, because, you know, if it's a particular shape of bowl or cup or whatever, I would argue that, you know, I'm not an attorney, but I would be very suspicious of that.
Yeah, I would argue that that's an original design. I mean, otherwise, you know, we could say that about language. So I don't know if you've changed. Yeah, I think if you've changed the color and you've put it into your own format, then I would argue that that's your design.
Mm-hmm.
I don't know who told you that, but I think it's arguable. And the thing is, if you've got a logo, you don't want to copyright that. You want to trademark it. So you want to trademark logos, okay? So let me just be clear about that. You can copyright the words and the image, but I would be arguing that copyright doesn't necessarily yield you as much money as a trademark does, because trademarks are very much around your brand value. And you can allow people to use your brand in a way. It has a little bit more legal gravitas, if that makes sense. Basic object, I took legal class. Oh, okay, yeah, well, I've got a PhD in intellectual property, so I'm assuring you that maybe you could argue that your originally created logo from scratch using those images is trademarkable. I would say that's arguable.
Mm-hmm. Yeah. Anna was asking what your experience is in trademarks or legal issues advising.
Oh, okay.
So a PhD in law. And
I have a PhD in intellectual property.
Yep. So just a little bit of practice there. How many years of education is a PhD? Like way too many.
Well, it took me 7 years to do it. So,
yeah.
Yeah.
Just a few.
Yeah.
Yeah. So, I mean, this is like what she got her PhD in. So, yeah, just a little bit of experience on it.
Yeah. Yeah. And I've done a lot of mediations in intellectual property. So, yeah.
And, you know, just intellectual property is one of those things that I'm not an expert. I don't have a PhD in it. I'm just an MBA. But, you know, I know to be really careful around it and, you know, be aware of what I'm using and how I'm using it. And, you know, if I could convey to the people in this group, you know, and watching this video, anything, it's just to be careful of copyrights and trademarks and, you know, knowing the source of the images or music or whatever you're using for your social media or any kind of marketing or website.
Yeah, absolutely. You know, just be able to trace, if you can trace the source back, preferably to yourself,
mm-hmm.
then, you know, I think that's a really important component of particularly, I mean, everything, but particularly because we churn through content quite quickly, particularly content. So just be aware, just make sure that you've written it.
Mm-hmm.
Yeah.
Oh, very cool. Sounds like, yeah. Anything else, Kate?
I don't think so, unless people have got questions. You can go and have a look at your websites in your various countries regarding trademarks. So in Australia, you would look up IP Australia. In the US, you've got the I think it's copyright.gov, and then you've got USPTO, which is, I think, the US Patent Attorney Office. Mm-hmm. And in Canada, it's, I don't know, I think you just intellectual property something. I mean, if you just put in intellectual property or IP and gov into Google for your country, it'll come up. It's pretty easy. And all governments, in terms of, the Western world, so the United Kingdom, Canada, Australia, the US, have pretty good government regulation around this stuff. So, and if you've got any questions, you can look on my blog. I've written quite a few blogs on IP, like different things in IP. So, ways that you can stop people from stealing your ideas, the difference between copyright and trademarks. I've written a few different things just to help people understand the difference and why you would pursue one area rather than the other. But I think you also need to understand that there's a really wide range in there, and it's a very complex area. Each is a very complex area of law. So even things get kind of grouped together as intellectual property, they're all very discrete areas.
Yes, absolutely.
Yeah.
Fabulous. Well, thank you so much. This has been awesome.
It's my pleasure.
Okay, so guys, if you have legal questions, especially intellectual property, contracts, all of that good stuff, refer to Kate. She is an expert on this.
Thank you.
Thank you so much. And so we will see everybody the next time.
See ya.
Thank you. See you.
Bye.